Would you help in that kind of case?
All right. We coach the person in advance of the meeting. We don't coach them in a way that is similar to what a litigation standard case would involve, in which you tell your client, here's our position, stick with it, or ask for a lot more than that position so we wind up back where we started. The idea is these people need to talk through their problems so that they come to the best solution for the family, not win the game. So when I talk about a buffer, I'm talking about the ability to come to a meeting, express yourself, and have your attorney there as a buffer. So you might say the things you want to say to your spouse, not necessarily that you would say in the therapy session, but things that you might need to say about how the case will be resolved. So say, for example, you have some anger about how the marriage is ending. You don't think that therapy is going to benefit that situation, but you do want to be able to express your anger in a scenario, in a context in which you can get that anger out and then move on to the issues. Because oftentimes people are litigating and they're creating issues because they want to get the last knock-in or win the last argument. But when they're doing it through their attorneys on paper, it can waste a lot of time and really make the wheels grind on the fees and the time expended. So by having the buffer present for a four-way meeting, you're able to sometimes express things and we can work through them and get them out of the way and then go on to the meatier, the more important issues and get past the emotional issues.
Do you continue having four-way meetings then during the whole process prior to settlement?
From start to finish, we're having four-way meetings.
Okay.
There can be time in between, as Rebecca indicated, that we're gathering information, we're evaluating it, but the four-way conference is the engine behind this process. And if we reach an impasse, in other words, people just aren't able to reach agreement, we get together again and we brainstorm. What is the problem? What's getting in our way? And how can we get past this impasse? Do we need to incorporate another neutral professional? Do we need to bring in a mediator? Sometimes you still bring in a mediator when you're collaborating. Or what other avenue will get us past the impasse?
And sometimes an arbitrator, right?
We try to avoid arbitrators, because when you
you
reach the point of using an arbitrator, you're bringing in a decision maker, someone else outside of this family who will make a decision that may not come up with a solution that these two people could come up with between themselves that best serves the family.
So that would be a last resort kind of
I've actually never used an arbitrator.
Okay, I read somewhere about arbitrators being used, but it must be very rare. Some people I'm sure that are listening are saying, well, in a nutshell, what's the difference between mediation and collaborative law? Basically, is it that you've got attorneys representing you with collaborative law, right, Rebecca?
Right. Mediation is when you're going to use a neutral to help facilitate agreements and bring the parties together. As family lawyers, we're skilled in finding the time to mediate with a client. For example, a lot of people have come into my office who have been to mediators, and they come in with a mediated agreement already done, and the attorney has to then educate them as to what their rights are and what things are missing. Whereas in collaboration, your attorney is with you the entire way through the process, and you're in at the right time because you're there always advising your client, educating them, helping them to select options. Whereas in mediation, usually the attorneys are not present and the couple just goes into mediation. And sometimes they're not sure what to mediate, what the parameters of what the law is. And so it's true in collaboration, we can use mediators, but again, the attorneys are present with you, because the idea is to keep the attorneys there along the way, to act not only as that buffer, but when the emotions do run high with these couples, attorneys are trained, when we're collaborative attorneys, how to downplay the emotions and stay on task and kind of do gatekeeping and move the case forward. So that's where a lot of our training comes in as collaborative attorneys.
What if you, as one party who's going through a divorce, is excited about this concept and says, yes, I want to do this, I can do it, but your husband or wife is very leery, then what?
It takes a lot of education of the person that needs to be convinced to take part in the process oftentimes, because people have a very rigid and standardized idea in their head that a lawyer is there as a professional boxer on the other side. I'll never forget, a client once came to me and said, I feel like someone's being paid a lot of money per hour to come out and beat me up, and I'm facing off with a professional boxer.
Wow.
And so that is a horrible image of the profession, and not one that we want everyone to think of us as. Sometimes it's a fit, but it's not really ever a fit in a family law case. And so trying to convince a spouse to do it requires you send them to the internet, look at articles. The Hennepin Lawyer magazine last March and April ran a couple of issues that covered a lot of aspects of collaborative law. In fact, one article was pro and con. What are some reasons to do this process and some reasons not to be in this process?
So that was in '08, last spring.
I think that was '07.
Oh,
Those
'07.
were out.
Okay, people could check that out.
Right. There's a lot of information on the internet about collaborative law, some is from other states. No matter what you read about collaborative law, though, across the country, the concept is the same. So it's actually one of the few aspects of law that you can research on the internet, and you won't be misled by what you are reading.
People won't say, well, in Minnesota, that's not the case.
Generally not, that's right.
Are there some people that you know right when you first meet them that they are not a good candidate or the family isn't for collaborative law? And what kind of people would fall in that camp?
Usually you have to flesh out who you think as an attorney would be a good candidate. And so I usually have a very candid discussion with my client, because sometimes it is my actual client that would not be a good candidate. But the whole trick of it is to just learn enough about the husband and wife, no matter who's in your office, to see whether or not they are amicable to this process, meaning are they collaborative in nature, or are they going to play the victim? Are they going to be able to get along well and work with neutrals, like the neutral child specialist? And are they going to be able to do their homework assignments and information gathering, or are they going to just merely sabotage this process and use it as a delay tactic? So you have to be very careful to try to flesh out what would and not be a good client for this.
And you sign, and we sort of went over this very quickly, but you have a participation agreement that is signed by the clients and by yourselves as attorneys, correct?
Right.
And that really spells out what's expected, I assume?
We have rules of participation also that even go beyond that. So we have an agreement that's signed that we're all going to collaborate, we're going to have open discovery, transparency. In other words, no one's going to hide information. But in addition to that, we have rules of behavior for these meetings. So we go through the agreement, but also rules of behavior, such as stay future focused, not past focused. Be respectful of one another. Talk in terms of, I feel this way, I feel that way, but don't be accusatory and say you, because that's been going on in the marriage, during the marriage, which may have resulted in the divorce. So from a problem-solving perspective, you need to have the respectful behavior, the I-focused behavior, the respectful behavior to make this process work. And those are some soft issues, but they're really the most important issues of all in the process.
And those are really, aren't they, the basics for great conflict resolution, whether it's with, attorneys present or at your kitchen table talking about who's going to do what this week.
Right. It might be a fantasy to solve family problems in a courtroom, but we all know that's not the best way to solve family problems. So family law has always been a misfit, a miscreant to be in the litigation courts, and people, and the courts especially, are finally recognizing that that's not the right place for family matters to be resolved, except in very rare cases, and never when there are children involved.
So when we talk about the benefits of collaborative law, one is that you get a model to go forth with in your new definition of family, your new form of family. What about cost? Is it generally cheaper to go this route?
It's designed to be more efficient. So for example, instead of getting the home appraised by two different appraisers, you neutrally decide, okay, we're going to pick and select this appraiser. So right away there, you've saved. You're streamlining the process, and you're avoiding court appearances. And so generally, my clients save money by going through this process. But we don't try to say, oh, be sure to be in the collaborative model because you're going to get a cheaper divorce, because it's not necessarily.
Well, each case would be so different and driven by so
the
many
complexities
factors,
of the
I'm
case.
sure. Yeah. We just have a few minutes left, about 4 minutes left. You've both alluded to the use of experts. Can you speak just a little bit more about that? And are they brought in frequently to the four-way conferences?
We do use experts a lot in collaborative law. They'll actually join the conference if there's a reason to have them there in person. Oftentimes they issue a report because they've interviewed the children, or they have appraised a home or appraised a business. So you don't need the physical expert in the room during a four-way conference in most cases. But the idea is there are many experts that are taking part in this collaborative process and are willing to abide by the collaborative process rules. So there are actually rules that govern the expert. And one very important rule it's important to cover is that once the expert has given their opinion, that opinion is going to be sacrosanct from court. So if the matter has to proceed to a courtroom, that expert opinion can be tossed in the wastebasket because it's no longer going to be used for court purposes.
So that's another reason to be motivated to settle.
Right.
And there's
Plus,
a lot of reasons here.
Plus you're going to get a better expert and a more cost-effective expert, because many experts in many areas do not like to get anywhere near a litigation matter. That's why for family law matters that litigate, we don't have a lot of experts to choose from because so many professionals, accountants, psychologists, appraisers, don't want to be in the middle of a divorce situation. They don't want to be shot down in a courtroom under cross-examination. But if you take away this threat of court, it frees up the clients, it frees up the attorneys, it frees up the experts. Everyone can do what they need to do efficiently and without that threat.
One last very quick question. What percentage of cases that use collaborative law reach settlement and do not have to go to court?
I know the answer. Minnesota is tracking these cases, and there is a 92% settlement rate of the reported cases. The interesting fact that has not been explored, though, is of that 8% that haven't settled, have they actually gone on and had a full-fledged trial on these same issues, or do they settle relatively quickly after they've left this process?
We have some resources for you. Get out your pen and paper. The first resource is Charlie's law firm. It's Goldstein Law Office, PA. The website is www.familylaw.com, or they're going to have a new website, www.goldsteinlawyers.net. And the phone number is 763-450-1500. Now we also have a website and phone number for Rebecca's firm, Grandchamp, Guyette, and Cronin. And the web is www.ggclawyers.com. The phone number, 952-249-9705. Well, this has been a very informative show for me. I'm sure for you too. I'm very impressed, as I have told my guests, about the whole concept of collaborative law. So I hope you can look into it, and I will see you next week. Thanks for being with us.